We ready to go?
Yeah.
Okay.
Sorry.
Call the meeting to order. Good evening. This is the regular meeting of the Architectural Board of Review, May 7th. Roll call, please, Michael.
Okay, Member Wicks,
Present?
Member Straight Here. Member Kerouac,
Here.
Member Dahlman,
Here.
Member Cottrell,
Here.
and Chair Hunter,
Here.
and Member Deegan is absent.
Okay, consideration of the minutes of April 2nd. Any comments, changes, questions? Yea, nay?
I move to approve as submitted.
Okay, no more questions? Otherwise, this is a, say aye now. isn't it?
No, we need a second.
Is there a
I need a
second?
second.
Yep,
Didn't-
Second.
okay. Scott, got a second? Okay.
That's a voice vote.
Yeah, okay, all in favor, say aye.
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 Okay, anybody in the audience or on TV that would like to participate or has something to bring up that is not on the agenda tonight?
We have no one on Zoom.
And I know who you folks are, so we're good to go. So the next item is the consideration of fire sprinkler exemption request for 960-970 North Shore Drive. And Michael, you laid something on our desk today that's,
Yeah, we made a slight revision in staff's draft of the resolution, or a slight revision to section 4, that I laid that at your place there.
has anybody had a chance to read it? Art, do you have any comments?
On the draft resolution, the only thing I was wondering about was, this is the first one that we're gonna do. And we are setting precedent at this point. And it seems to me that under section 5 of the conditions, what we're asking is to improve the fire safety of the building without requiring sprinklers.
Right.
And,
Other requirements that are added, which are listed here.
right, those requirements that are listed there. And I was just wondering if we wanted to expand that in any way. You know, my thinking is like fire extinguishers, emergency lighting, exit signage, you know, those kinds of things, you know, so that we're being as thorough as possible as far as upgrades to life safety.
Somehow I thought we had that covered, not necessarily by detail, but
Yeah, it's a good suggestion. I don't think it's in there right now.
I know we talked
covered
about
specific
pull
things.
stations and more, you know, more detectors and so forth.
If we want to add something like that, could it be added in a separate paragraph, added to section 5 that says, and the owner is also required to comply with all other provisions and requirements?
I'm not sure that it's not already in the building. As far as,
So there's two parts to your question. We can add additional conditions or requirements for the property or for the owner. So that's, you're not boxed in just by this. So that's the first. We can add additional requirements, like we haven't talked about fire extinguishers, emergency lighting, things like that. So that's the first part. We're not boxed in just by what's written on the resolution. And then second, we could always add a, a catch-all provision by any other requirements in the village code, but I think that's already, I'll double check if that's, yeah. Yeah, so we already have compliance with regulations. That would be, the first one is kind of your catch-all for development use, maintenance of the subject property must comply at all times with all applicable village codes and ordinances. So we could go back and check to see if we have fire extinguishers, emergency lighting for certain requirements already, but that would be,
Yeah, I mean, so the number, section 5, number 1, compliance with regulations, the regulations don't necessarily say that we should go into an existing tenant and have them change things if they, don't meet today's code. So if we want to do that review, which is actually maybe a good idea for things like fire extinguishers or emergency lighting, we could
then we would want to
say so as a
include that.
condition.
Yeah, we would want to
right.
include that specifically.
Because someone
as a
could be
condition.
existing non-conforming to a certain
True.
extent to those.
As far as exiting and exit signs, each one has got two doors and they are signed, as far as I.
Right, I understand that,
Yeah,
but.
but some of the other things you mentioned, I don't remember. I know there's
Right,
pull
and
stations.
I guess my thought would be, my thinking was along the lines of, either staff, village staff, or a consultant that the village hires, inspect the building carefully, looking for any, violations of, the codes, or things that, I don't know I have no idea what they might be, but, say flammable materials or, just things relating to fire safety that over time, things get done to buildings and modifications are made, spaces maybe are subdivided and, and at any rate, it would just seem to me to do something, quite thorough that, along the lines of kind of going with the intent of the original ordinance, which, by mandating fire sprinklers, the intent was to improve the fire safety of buildings. And that, what we would be doing is kind of furthering that intent without the requirement of a fire sprinkler.
Right.
Could we respond?
Sure.
So, I'm Nick Standiford, 70 West Madison, Chicago, Illinois. I live over in Lake Forest, though. I'm here tonight for the applicant. So FSCI did a report that was in the packet before the meeting, the public hearing. And that's the fire safety consultants Inc. And they looked at the building and went through all the different spaces. And on page 4 of the report, they did what you're talking about. They looked at each of the units and asked, do they have a full fire alarm? Do they have a fire exit? Do they have an exit access? Do they have emergency lighting and exit signs? And all the spaces checked out. There was one that said no, and that was for the retail. That was the full fire alarm. That was in the McElroy Firs. It wasn't integrated with the central alarm. And so that's what they flagged there. But FSCI did go through the building and did exactly what you're saying. And they thought that it checked out.
Right, and I understand that, but I was thinking more in terms of the future. That in other words, that there would be a process whereby, again, either the staff or a consultant visited the building, thoroughly inspected it, and, issued a report in essence, these are the items that we think should be addressed.
And Mike, you'll do this every time an applicant comes forward, right? You'll hire FSCI to do the same inspection.
That is the plan, yeah.
And could that be an ongoing, like every few years or whatever, that it gets inspected?
Well, we hadn't talked about doing that, but certainly this board has the power to add conditions to that if you want to add something like that.
That seems like doing it over again.
Yeah, we don't do spot reviews for other properties, right? I mean, after something's passed code.
Right, exactly. And that's true. That's a good point. And, you know, a lot of times, there are towns that do annual fire inspections, and maybe someday we will, but right now we don't. But if we
Yeah.
decided we wanted to, that would, you know, to check the emergency lights or whatever every
Right,
year.
yeah.
That would, presumably, we would do that, you know, if we do that for everybody else too. Yeah.
Yeah, doesn't the fire department do periodic inspections?
They
in
have
commercial
not
buildings?
been
Oh,
for
they've not,
quite
okay.
a while, yeah.
So what does anybody think about Art's thinking here?
Well, I think those issues have been verified for this property, correct? What you've been asking for from the report from FSCI?
That was my impression.
My recollection of the report, there was something along the lines of a disclaimer as to what they didn't look at. For one, they didn't get into McElroy firs. They did?
Yeah.
And they didn't get into the border patrol.
They got in there.
Oh, they did?
Yeah.
Oh, I believe so, yes.
So,
You know, if
I
we're
know where you're
confident that what FCI did, you know, satisfies the idea of identifying any deficiencies in terms of fire safety or life safety, then I would say that's fine.
okay. Neil?
I don't have any more comments.
My only thing is there, maybe I just can't see it, a stated date that all of these have to be implemented by or
Well,
something?
it's the original date, I assume, 26?
So they just need to meet our new markers by,
So, well, the code has the January 1st, 2026 date for fire sprinkler retrofit
Right.
currently. But if we, you know, this resolution that we approve is granting a permanent exemption to that.
but what I'm saying is the items that we list that they must satisfy.
Oh, yeah,
is
presumably
there a-
they would have to meet it by January 1st, 2026 because they need their exemption to be in effect by that date.
Okay,
So.
is that,
right.
yeah, I just
Yeah.
didn't read that as
Right.
specified, but that's understood then?
Yep.
Okay,
Right.
that's all I had.
So we were talking about Mike's resolution here that he left on the desk. Anybody else have any comments? Matt, did you?
No, the only other comment was, I don't know, for the, you know, if we need to be specific, like with the boarding, the animal, like there's some type of plan made for that. Is that, did I miss that? Is that something that we should?
Well, there is.
So,
And you saw
yeah,
it.
They said they made arrangements with.
Yeah.
the,
Okay, I just didn't know if we
RRA put
needed
it
to
in the
do,
fenced
okay.
in
Yeah,
area.
and-
I just want to make sure that we were just talking about things we wanted to do. So if that's satisfied, then I'm satisfied.
Scott?
I have no questions, no.
Sue?
I kind of understand where Art's going with that, is if this is gonna be kind of a template for multiple other people coming, are we all sure that we've got it all in here? And as far as hiring the people to like review the space, do we need to put that in there? Like, we will always do that and they need to, you know what I mean? Like, is there, I know where you're going with this, which is it all kind of in here before we go, okay, this is it?
Yeah, as far as having the consultant review other applications, I don't think this is really the appropriate place for that. I think we did say that, though, when we did the code amendment last
Okay.
year to create this process.
We don't want to
which
do
is
it
why we-
again.
Right, which is why we did it.
Okay,
Yeah.
so we would always just be doing that as, because
Yeah,
it's somewhere that we would normally
It
do
is,
that.
yeah, it is in the code.
Yeah, then I think, and then you asked my other question, which was, is there a date by which it has to be done, and is there some way to verify that it is done? Yeah?
Yeah, I mean, I would verify that it is done before the January 1st, 2026 date.
Mr. Brown, yeah.
Yes,
Comments?
thank you. Yeah, just a comment to the date. I met with our
alarm company with Mr. McElroy, and we kind of worked a schedule when his warehouse is cleared out to make that more, that easier to do. But first of all, it's been a long road, and thank you for the work that's been done. And it's been more than I imagined. I'm sure it's more than you imagined. But we do have some comments on the resolution, which may appear to be a bit like filleting the flea on this, but I think they're important in that we're all going to have to live with them, and I need to understand those conditions because in the years to come, if I don't comply, I go to jail, and I don't want to do that. So I would like to just comment on mainly one thing, point 2. And Mr. Croak and I spoke about that, and he did give me some clarification as to how that applied with the condition, with the if condition. But yeah, for the future construction. But relating to further governing codes that concern this, you know, in the interpretation, and you might not use the IEBC, and you might use another code system, and you just put it under the blanket of Lake Bluff codes. I feel like that leaves a little bit open to interpretation and some, I guess, some idiosyncrasies that might exist in the code that might arise in the future that are not administered by a national governing body. And that's where I sent Mr. Croak a draft of language that would incorporate the IEBC or a national code that the Village of Lake Bluff would adopt. And this might seem like a petty thing, but I just feel a little uncertain as to how this would move forward and how it might be interpreted in the future. And my attorney has drafted something, and Mr. Croak has a draft of what I sent, and I'd like to maybe just have some discussion around that, and my attorney can elaborate.
Thanks, Ted. So let me I learned by seeing things. So what I did was I marked up the resolution with what I think the changes could be for consideration based on the vote that was taken at the last public hearing and the discussions throughout. So the first page is obviously unchanged. Wait till that goes around. So the first page is unchanged, the second page is unchanged, and then the third page. These are the conditions. These are what Ted says, this is the stuff he has to live with, so he wants to make sure he knows what he's gonna be required to comply with. So, under number 2, so what this one is talking about is when the building is required to be sprinklered, right? This isn't a permanent exemption for the test of time without any conditions. This condition says that if there is a building permit that's pulled, or a change of use or occupancy type, or is improved with an addition, the owner will be required to add an approved fire sprinkler system at the property. And then it goes on to say, this is the important part, if the sprinkler system would be required due to the proposed work or change by the applicable sections, and right now it says, of the building code, in effect at such time of the proposed work or change of use or occupancy. So we're not really sure what that means. The concern here is that Yuppie Puppy gets a building permit. Then does the whole building have to be sprinklered? Under any of the Lake Forest or Winnetka or any of those other ordinances, that would never happen, where one building permit would trigger everything. Usually it's measured in the International Existing Building Code, which I have a handout on. It measures it by 50% of the floor area. Member Dahlman mentioned this during the public hearing. There's a 50% rule. If you're doing 50% work on the floor area, then you have to put in sprinklers. The International Existing Building Code also says if you have this change in occupancy classification or change of occupancy within a space where there is a different fire protection system threshold, basically then you have to put in sprinklers. So I thought that it would be clearer if we pointed to the international existing building code and the requirements that flow from that, which is the 50% rule and it's the change in occupancy rule. And so what I did was I basically just took screenshots of those provisions in the international existing building code. So this is what we think would, if work gets done and it triggers the international existing building code, then the sprinklers would have to go in. The first one talks about the occupancy, the second one talks about the 50% rule. Because right now, there's no definition for building code, so I'm not sure if it's the international building code, which says that all buildings have to be, new buildings have to be sprinklered, or is it the Lake Bluff code? Like, we're not sure what that is. So if we could have some clarity on that, that would really help. That would really help a lot. So I guess my suggestion is that we go with the international existing building code. It covers any future improvements that this would trigger the sprinkler requirement to come into place. It's fair, it's been tested by the international community, and it's been agreed upon by many municipalities who have adopted that existing building code. So that's the first one, and that's really the big one. The number 3, 4, 5, these are just kind of making it a little cleaner. But that's really the one we have an issue with. So number 3, if actually, let me ask, are there any questions about the changes to number 2?
I just need a minute to finish reading it.
Absolutely,
Hang on
and
a
it's
sec.
just the part that's highlighted.
All right. Not down, just this top one?
Yeah, just the top part.
So, hang on, just let me think a minute.
No problem.
So, it's saying, so what is this saying? It's
It's
saying,
basically saying if you have a use now, you have
Right.
the yuppie puppy there now.
Right.
You change that use to something that requires a higher fire rating,
Yeah.
then you have to put in sprinklers.
just, it looks like it's saying such systems shall be provided throughout the area where the change of occupancy occurs.
So I guess you'd put it in that
One
area, yeah. But as Mr. Brown told you, to put it in one area, he might as well put it in the whole building at that point, right? Because he's got to run the water main to the building. It's probably cheaper to run the piping throughout. It's not as you heard from FSCI, doing it kind of piecemeal is not the most efficient way to do it.
So, but this is the International Building Code. one,
International
right?
existing building code.
Right, so, but isn't that saying that it wants you to do what you don't want to do? I mean, isn't it,
But if we trigger it, that's if we
Yeah.
trigger it.
Yeah,
It doesn't say we have to do it, but if we trigger it, we can.
We're-
And that becomes my decision.
yeah. So we're okay with putting sprinklers in once that's triggered.
okay,
And that would be on a per tenant basis,
Well,
right?
That's gotta be figured out, but,
Is there what up-
or 50% of the entire building would trigger it as well.
And that's on the other flip side of that sheet.
Yeah, okay.
So the main reason why we didn't.
Yeah, sorry, and
I'm
it
still
took me a while to
confused.
wrap my head around it today.
Yeah.
here's,
So,
can someone, yeah,
just to clarify,
Yeah.
the main reason we didn't say that initially in our staff write-up is because what if the title of the code changes? Or what if we adopt a different code decades from now? You know, this code has been around since early 2000s, but the International Code Council hasn't always had a code of this title, and, you know,
Okay.
maybe they'll change the title in the future, and this is an agreement to last forever. So when we said our reference building code was a generic reference to whatever the village has adopted at, you know, at each point in the future when these remodelings or changes of tenants occur.
okay. So, is the village building code different from the international existing building code right now?
Well, right now, I think the two different wordings would have the same effect. The only question would perhaps come in the future if the title of the existing building code changes. You know, this is locked into that title forever. I guess also the building code reference that we had, it's clear that it's holistic, so if there's something like if someone puts a restaurant in and they have to have the extinguishing system under the hood,
Yeah.
you know, does that requirement come out of the existing building code? It really comes out of the fire code, you know, so it's clear building code includes everything. you know?
So with that clarification, I think we're okay with that, as long as, I think what, and the village attorney might agree, maybe you don't capitalize building and code, because then it's generically building code. But otherwise, with that clarification from Mr. Croak, I think we're okay, we can live with that.
Okay.
Right, Ted?
Yeah, I think we'd be happy to not capitalize then.
It's the IEDC or.
Ted, you gotta come up. You gotta come up.
So as long as we're using those two things interchangeably, IEBC meaning or a standard code adopted by the Village of Lake Bluff encapsulated in the building code, yeah, I'm fine with that, as long as that's what we're dealing with, not an amendment to the code that is just local.
Well, I mean, the building code term includes everything that's there. I mean, it's local amendments plus the national codes, right, would all be
Yeah,
included.
I guess, and Mike, we spoke of this, I get a little nervous when you put into that any local amendments that, like, well, the village can operate more unilaterally than a national building code. So the village could unilaterally do some kind of amendment that's like, oh, that's very onerous, and I don't know that I can, it's out of the norm. But when you use a national code, it tends to be more standardized and accepted and adjudicated on a national basis versus a local amendment. Like the retroactive sprinkler code is a local amendment to the building code. And I can't, at this point, imagine what that might be to trigger it, but it's like I'm a little concerned because, like I said, I go to jail if I don't put them in. So.
Yeah, I was talking to somebody who was considering buying a new house the other day, and they were asking, if, getting a certificate of occupancy meant those plumbing materials in the house would always be allowed forever. And I said, in the 1950, when we issued a certificate of occupancy to people who had lead service lines, but it's, by 2030 or something, they have to replace them. It's not guaranteed forever. What we build today or what we do today is always subject to future changes.
Well, and I imagine that requirement is a national requirement, is it not? The lead pipes?
It's not a national requirement.
Is it a Lake Bluff requirement?
It's a state requirement.
Okay,
coming up.
all right. Well, again, that's a little broader than just Lake Bluff. That's my concern.
Yeah.
You all will have to fillet the flea here on it, but that's my concern.
Would an applicant be afforded to come in front of us for relief from that new code?
Yeah,
I mean, it'd be the same.
presumably, right, presumably we still have the same process in place. They
Yeah.
would have the right to come and apply for an exemption to that, right?
Yeah.
Yeah.
All right. Chairman Hunter, did I sufficiently muddy the waters?
How did we leave this? Now, what are we gonna do? Just take the capital letters off?
We're fine
Make
with that.
which should be somewhat generic in a sense.
Right, yep. Yeah, we're fine with that.
Okay.
So you would pretty much just use this language rather than what's written here in this?
I think we're leaving everything the same, just
I think we just
a low B and a low C.
not capitalize building code because it's not the official title.
But what about the sentence that says, if the subject property undergoes any work or renovations that require a
Well-
building permit?
But there's the second if clause.
If
If
it
the fire
falls.
sprinkler system would be required due to the proposed work and change by the applicable sections of the building code in effect at such time.
That
So
50%,
is,
the 50% rule has been in,
I'm
Referring to
totally,
international
it's like,
existing
it's over my head at this
you
point.
know, the 50% rule has been in way before the International Building Code. It applies to historic preservation, it applies to so many things, and I don't see that changing in the next 50 years.
right.
But what defines 50%? So if somebody.
50% of the building.
So if someone replaces 100% of the carpeting, is that 50% of the space?
No,
Carpeting?
That's the complicated.
yeah, right.
Yeah, Highland Park had that craziness.
Are we settled on that? Everybody?
Are we what?
Settled on that issue? Mr. Brown?
I guess, no, but I defer to you all. I mean, Mr. Rock, yeah, I mean, you understand what I'm saying. I
Right.
just don't understand what the objection would be to stating something like the IEBC or a national standard code adopted in the future by the Village of Lake Bluff. I mean, it kind of puts that criteria outside of a administrative amendment to the Lake Bluff Code. I mean, Lake Bluff could conceivably say, oh, we're taking dog daycare and ratcheting that up to an assembly use. I'm like, well, that doesn't jive with the IEBC, but it's a local amendment that is part of the code. So I'm just worried a little bit about the vicissitudes of a municipality unanchored to a national code. That's my issue.
Well, we could develop hypotheticals forever,
I understand.
and I don't think that we want to do that. I'm,
So one other option, Ted, you could ask for existing to be in front of building code, so that everyone knows that the existing building code is being applied.
Yeah, I mean,
Would that be a reasonable?
Well, I think that would be problematic unless you're using it as it would be unclear whether you're using it as a title of the International Existing Building Code or just the existing building code, because if we're talking about someone coming in 30 or 40 years from now on a remodel, you wouldn't want to follow today's code, you know, the technology and everything has changed.
Yeah, I would make it not generic, I would make it existing building code all lowercase.
I think that was the most problematic suggestion we've heard tonight.
It would be, it would be the building. It would be the building code adopted at the time of construction, whatever your.
well, that was
village's
But does the
adopted.
village,
1960-something.
but does the village adopt the
No, at the
international
at the time of
existing
the
building
renovation.
code?
Oh,
Future
well,
renovation.
basically, it's the same
I believe
thing.
it does.
Right, that is what we're saying in the existing text, actually.
I would ask this, if we adopt another sprinkler code for some reason, right, after 2026, we would still have the same relief?
Presumably, I mean, unless this body, recommends and the
That-
village board adopts.
Because
something
applicants are
different.
being
Yeah,
difficult?
Right.
next
Yeah,
one's gonna be a
no,
slam dunk.
Yeah.
Right.
I just think a total clearing seems wrong. I'm not, because who knows what's going to be. I mean, for them to only be held to today's standards seems like what they're asking for.
And what we're saying is the chances of today's standards changing are slim to none.
Yeah,
At least
and
that's
if they
what I-
do change and they can come back in front of us and say, same hardships that we had in 2024,
Right.
then we deal with it then. But I think that, I mean, if we find out that something, asbestos, right, we always find out new things.
Right.
I would hate to give them or anybody get away from the code as much as we already have,
Right.
is my issue.
So it would seem to me that what everybody sort of agreed to, at least at this table, was to take away the capitals and make it more of a generic sound than the particular, and you were okay with that, right?
Yeah, that's fine, yeah.
Okay, yeah, and with that clarification that we've received here tonight, I could sleep a little better.
And then number 3, 4, and 5 are not as significant. The reason we're proposing this change, it currently says the owner must replace its current system, which includes 2 fire alarm system, with one centrally monitored fire alarm system at the subject property. So we're not going to replace our current system. What we're hoping to do is just integrate or connect the 966 unit to the existing system. I don't know if
Yeah, that seems fine to me. That
That
makes
was,
sense.
that was kind of the intent.
Yeah, I totally, yep. And then for 4 smoke detectors, Mr. Brown and I had a discussion. It sounds like the fire chief does get a say in where the smoke detectors go, so that's fine if you want to leave it as is with village staff. We thought a licensed fire protection professional may be a good person, but if the village wants to leave it at village staff, I suppose that's okay.
Okay, yeah, we're happy with the existing wording.
Okay. And then 5 alarm panels. So the owner must install, it currently says the owner must install an addressable alarm panel that indicates to the fire department the location of the smoke detectors that sent the alarm signal. So it's already in there and it does that. So we thought it maybe should just say the owner must verify that the subject property has an addressable alarm panel. And that would mirror the language of smoke detectors above, that the owner must verify that the subject property has the required smoke detectors.
Yeah, that language seems fine to me.
But the alarm panel is not in the building anywhere, as far as I know.
But no, they do have an alarm panel.
Where is it?
I don't remember.
You mean an
exactly.
annunciator panel that shows where in the building something's going on?
Yeah, do you? Yeah.
It's next to the lockbox, it's the unit with the lockbox, so that the addressable panel is inside the door.
Okay, I didn't realize that. I thought that's what we were asking for. I thought that was chief asking for.
No,
Okay.
No.
That,
So with that clarification and those minor changes, we really appreciate everyone's consideration.
Okay.
anybody else have any other thoughts? Because I've got one. Okay. And in a sense, it deals with process. When we had our last meeting, and subsequent to that, we did not have a unanimous vote on that, which is most of the time we do. And so I got thinking about the process, and in a different meeting, totally different subject with Drew, and it doesn't matter what that meeting was about. We have in the past, except for one issue, which was totally not relative to this, all of our decisions go for finalization before the village board. This one doesn't. So to me, that's a switch in process that doesn't seem to make a lot of sense, considering, we got the expertise up here, but the village board on important issues, I would think, likes to have a say. They may go along with this, they may not, but I would think that the way to deal with that is to add another item to to this resolution, which would be that it has to go before the village board, not be approved or not disapproved, but it has to go there. And we talked about that. It's probably 10 days ago, anyway. And so I want to see what you guys think about that. Because it's really kind of following our procedure that we've had forever, which right now, this doesn't have to go to the board.
So would that be just sort of an information thing, that, by the way, the ARB has granted this waiver? Wanted you guys to be aware of it? That's,
No, I think they have to go along with it or not go along with it.
well, that's what I'm saying, so they have to approve it.
I mean, that's what I think.
Oh, okay, I didn't understand that.
Yeah.
They thought, okay.
Well, what is this on the last page that we've got here, where it goes to the village and it says first reading, second reading, passed, approved?
That was this.
Yeah, isn't
Oh, that's
that?
just a standard form that the village, that
Oh,
we,
that wasn't
that we just
intended
use in
for
the
this.
village. Well, that's just a Lake Bluff Village resolution form.
That means that would happen with this resolution right here.
So we're saying this doesn't belong on here.
It does. Well,
Well, then,
no, I take it back. It doesn't. It's a standard form that goes attached to all resolutions. It doesn't belong on here.
Right,
But I guess I'm saying,
I guess if,
I'm suggesting that maybe it should, because everything that we do gets transferred to the village board for their approval. But everything we do is not based on a resolution, is it? I mean, we don't,
Correct, it's not.
it's not a,
I guess I'm mixed on that, because I think that there's things that we do that should be able to be approved by Mike administratively, you know, relatively minor things that come to the board. There are things that are a little bit more complicated that should be handled here based on Mike's discretion. And then there are other major things that should go to the board. I don't think it's a cut and dry that says everything that we do goes to the village board.
but it does.
Yeah, well, I'm saying I think it shouldn't.
But,
So I'm not in favor of setting a precedent that says, here's one that doesn't have to go to the board to change.
that's my point. Right now, it doesn't have to go to the board, and everything else we do does.
Is that right, Mike?
Well, we do have it set up in the code the way you're talking about, Neil, and in fact, we amended that with the code amendments
Yeah.
over a year ago. So there is a administrative approval for really minor things, and then, you know, somewhat minor things, you know, a final decision here, and then major decisions are a recommendation from here to the village board. So all the major decisions generally go to the village board. And it's minor stuff that are final decision here. So-
Yeah, and this seems like major.
This is major.
Well, that's,
Yeah, I've always
what
felt that.
what bothered me a little bit was that we weren't unanimous here. And that's okay. You know, we don't need to be. So I just want to get your thoughts on that.
Has anybody spoken to anybody at the village board to get, like, if they felt that this is something under their purview?
Say that again?
Has anybody spoken with any members of the village board to see if they felt that this item should be under their review also?
Just Drew and I had the conversation.
Okay, I didn't know if they have an opinion on that.
I don't know. I don't think so.
It's possible that when the village board passed this ordinance not requiring it to go to them, that maybe that was their intention.
They don't know.
Well, that doesn't affect this one, right? I mean, we can't retro.
Yes, we can.
Oh, we can.
That's what I'm asking. Should we add, because it hasn't been codified yet, should we add that resolution to this resolution?
we can add a condition that it would be subject to board concurrence.
So can I say something? So the current ordinance says that if you deny the application, then it goes to the board. But in this case, you recommended and you voted to approve it, and so it doesn't go to the board. That's how the ordinance currently reads.
They haven't voted.
I
Well,
mean,
they voted last time,
They directed,
correct. So, and I think everyone's agreed that this one meets the requirements.
the board still has the authority to adopt conditions, to adopt certain conditions, and if they, as tonight, if they want to adopt a condition that they want it to go to the board, subject to concurrence, that's within their purview.
The board, the text amendment says that if you vote to approve this exemption, it does not go to the board. And last time we were here, you voted to approve it.
Subject to conditions, and they are still able to add conditions, just like we amended other conditions tonight or other proposed revisions.
I would say that's doing an end around of the legislative decision that was made by the board to give you the final decision. So if the board wants to make another legislative decision in future applications, to have the application go to the board, that's what I would say. But we've been through countless meetings.
So have we.
Countless meetings, I know, and we've worked hard and we've demonstrated we met the standards under the current ordinance. And to send us to the board at this point would be challenging for us, and we've done a lot of work here. And we'd ask that you vote on the approved, the ordinance that you recommended and voted to approve last time, and the conditions that we just discussed, and the language here. Thank you.
And to that, I would say it is still up to the board to impose certain conditions. That's within your purview.
Chairman Hunter, explain to me again why you think this would be useful for the board to, essentially have a say, or, a concurrence or whatever. It's not that I
They don't have
disagree
to
with you or
concur. They
anything.
can concur that this is an exemption, that they go along with it. That's fine.
Right,
Yeah. We're not trying to get out from under granting the exemption.
right.
I'm trying to follow a process that we've followed, at least what I assumed we had followed, where the information that the approvals that we give on everything that comes before us goes to the village board.
Okay, I understand now.
And-
Okay.
But I think that if it doesn't go to the board, we are following the board's direction. They passed an ordinance that says the buck stops here.
But they still approve it.
No, they've already sent.
Oh,
they've
here,
already
they
signed
didn't.
Something that says,
I don't know that they passed an ordinance that says that the buck stops here.
yeah, they have. The only provision, as Attorney just pointed out, the only provision for it going to the board is if we reject it. Then it has to go.
Then it's an appeal.
Yeah,
Then Mr. Brown would have a right to appeal.
but if we approve it, there is no provision for it to go to the board. That's in the ordinance.
Where are we, Courtney?
Well, the ordinance states that this board does have authority for that, but can also approve in part with conditions or deny, or, so it's not just a one-size-fits-all.
That's right, we could add another, well, like you said, we could
Yes.
add another condition that
That's all I'm
says
saying.
we want it to go to the board.
Yeah.
Yes.
Yeah, I just get the feeling we're sidestepping our authority if we do that. And we're setting a precedent that everything we do we want it to go to the board. I don't particularly want it to go to the board.
It does.
It doesn't, well, I don't care if it does or doesn't.
Even the little sign things go to the board.
Well, not anymore. We changed that.
Well, yeah, we changed that,
We
but
changed
it
that,
used to.
yeah. Right.
Yeah,
What do you guys think?
So did the board, who initiated this? I just want to get a little history here, because I always felt that this was a very high kind of reach, to do this exemption for sprinklers without some kind of body.
Are you asking who had the idea about the exemption way back, last year when we did the code amendments?
Yeah.
That really came from village staff.
So village staff.
Yeah.
And then did they say to the village board, you don't need to approve this? Or did the village board come up with this and they said they don't need to approve this?
No, I don't recall much discussion with the village board at all about that distinction as to who would have final approval, ABR or village board. I don't recall that being a topic of discussion at the village board level.
Mr. Drew?
I think my best recollection of that was to give a process internal to the village for petitioners to have an appeal body within these walls. So the idea that the ABR conveniently, were dealt in this universe and could render a decision, and then if a petitioner didn't like that decision, that the appeal body can be within, to avoid going to the circuit court, having it being solved some outside of the community per se. And that's, it's like a convenient design for that sake.
What other boards, their decisions don't go to the village board? Like, say, the zoning board of appeals, they issue a variation, does
Yeah.
that then have to be approved by the village board?
Some of that is statutory. Illinois law tells who has what authority, but generally speaking, most of the advisory bodies in the village are just that, advisory. The Plan Commission, Joint Plan Commission Zoning Board of Appeals has certain statutory authority, but it also has authority that the village board has granted it to grant certain minor variations, and the major variations and text amendments go to the village board. So it's similar to what you all have. I mean, Mike's right. You know, over the years, the village has been trying to make procedures for applicants, business in the community, to have administrative procedures available to them for light lifting things that have been done before, and then try to have procedures more higher scrutiny for more difficult issues. So that design is like the most recent review with like design review. There's 3 levels of design review now. Some are staff, some are you all, some go to you all, then the village board. And again, it's that, as Mike described, more intense questions. Yeah, so through that continuum of difficulty, so to speak. But generally speaking, the village board is the final authority on most things.
So let's say something tragic happens. Let's say 5 puppies die in a fire, right? And those owners sued the village, knowing that we exempted that place from having sprinklers. If the village board had approved that, is that more protection for the village, or it doesn't matter what board?
Discretionary immunity under the Tort Immunity Act, doesn't matter.
So we're not overprotecting or underprotecting ourselves one way or another.
You're making a discretionary decision.
I think the idea when Chair Hunter brought this up, so you tell me if I'm wrong on this, Bob, I think when we had this conversation, the idea was this is an issue of life safety, that it's of a magnitude that he said, why did we set the process that way? It seems different and counter to what we've done normally. And is there a way, could we do something differently? And that's how we arrived at this conversation. So yeah, you could. And that the idea that this particular petition may be the most difficult, and then kind of talked about like that at the last couple public hearings, like this, you know, of all the petitions to come first, this is not necessarily, you know, it's obviously you guys have been struggling with it. So the idea of that is, you know, I guess the idea, it could be another set of eyes on the issue. They may not want to hear, but at the same time, that's something that I was asked, what could be done procedurally that can be done. You can add this condition or a condition that would say this request exemption is approved subject to the village board's concurrence. And they can come back and say, yep, we're fine with that, or no, we want to have more hearings, or just refer it back to you all. Say, nope, you make the decision. I mean, that could be I don't know what they're going to do with it.
Yeah.
But that was the question that was asked, and so that's available to you all if you feel like this is something that warrants another set of eyes.
This is totally
No.
changing the rules on us, but
Let me just say what I also offered to Drew, that made sense to me. It didn't even occur to me that you folks might want to attend a village board meeting to do this, but that I would. And I would explain our situation. And I would repeat what I said that night. And I would also suggest that if you watch the recording of that entire night, everything is there. And if the village board were instructed to watch that, it's an hour long or something like that. You were there. That they would have a better understanding, because my reaction was that, oh, well, that's a knee-jerk reaction. Of course we want sprinklers. I don't want that reaction. We voted to grant the exemption. We're not changing that. You haven't voted to grant the exemption. No, you voted to direct staff. Right, yeah.
granting conditional exemption.
Yeah.
Yes, thank you.
Okay, thank you. I talk in big. So anyway, that's one of the things that I would do in a presentation to the village board. I would make it.
We appreciate that. And our suggestion would be that the village board, Drew can work with them on a text amendment to send it up to them, send your recommendation to them in the future. But we'd like you to vote tonight to grant our exemption under the current ordinance as written.
Well, that's up to us. What do you guys want to do? Right?
Yeah, it's up to the board.
What about just having them review the resolution, but not overturning the decision? You know, if they want to add comment or whatever to the resolution, they could, but they couldn't overturn the decision. Just a thought.
I don't know what that does.
Well, otherwise it seems, to me, it seems kind of redundant, you know, because we're starting all over again with the whole laying it all out to a new group of people, but.
Are you asking something like where you would approve something that would have an effective date unless the board took certain actions, it would be in effect 30 days from now, or by the, you know, some period like, I mean, that can be, I mean, that's a little, I mean, it makes them take an action, it makes them take up the issue, right, or not. They could say, well, we'll leave it lie. You follow what I'm saying?
Say it again?
And I don't know if, Courtney, there's a more graceful way to say this, but that you could have a condition to say that this will be effective unless the village board, you know, there are some procedures on the books in the zoning code where it talks about unless there's an affirmative action taken by the village board, then the default answer is the exemption is approved as presented by you all.
I could see that.
It's a middle
It's a little more
ground.
complicated, but.
Yeah, I don't know. I feel like it's a pretty big thing because I feel like we're gonna have people coming, obviously, on that list. Whether or not these guys, but I do kind of think it might not be bad to have the village board approve it after we do in the larger sense. I don't know about this sense, but I don't know. You know, I mean, it does seem to be a pretty big thing. And, I don't know.
This whole thing's a big thing. You know,
Yeah.
that's what's the problem, I think.
Right.
This is our first one, and I know you've been suffering through it.
Yeah.
We've been suffering through it,
Right.
trying to make the right decision on a very important topic.
Because it just seems like once they're gone, that's one thing, but then there's gonna be more people coming with different issues, but the same problem, you know? And then, I don't know. I mean, maybe it isn't a bad thing going forward to have the village board weigh in with but still have our recommendation. I don't know.
What's the final date for other buildings to put their sprinkler systems in?
26?
January 1st, 2026.
26, so a year and a half,
Yeah.
okay. Because we're supposing that a lot of other people are gonna come, they may not.
Maybe they might not, right.
There's only 3 or 4
Yeah,
that would fall under this category. Some of the other ones don't apply at all.
yeah.
Well, I think there's a few more than that, but
Yeah.
I think there's like, I want to say like 10 or something. on
Well,
the
as far as office spaces, I mean, you got, yeah, there's the post office, the DeMarie stuff.
Yeah, we had 12 on the list, but some are like the Park District is one line on the list, and they have 4
Park
different
District, the
buildings.
the water plant, and the electric station. Those don't apply.
Okay, well,
Anyway,
So, for me, I think we either set a precedent, we've already, I feel, set a precedence. If we want the village board, and we say, let's do that for the next one, and it just feels like they're getting the benefit of our kind of freshman attempt at this. And the next people are, you know, maybe a more stringent view on it, just because we're learning our lesson, which I don't know if that's the right procedure here. I don't know how that would be for future applicants. You know, could they come back to us and say, well, they didn't have to go in front of the board. But the first, that feels,
Yeah.
I mean, I feel like we've already done a disservice to people who have, you know, not come in front of us and put their sprinklers in. And maybe none of those had the same issues, but we don't know. And they've jumped through a lot of hoops to do the right thing.
I think Those are good comments, but I'm not worried about the precedent, because if we do something in one case but do something in a different, there's nothing in the code that says we can't do that. If they want to take it to court, a judge could decide if it's a precedent, but that's really unusual.
I would say it was just more a matter of fairness.
Fairness is a better.
Yeah, that's,
Yeah.
You know, that, it seems to me that if we're saying next time we'll have the board weigh in, I think that's a mistake. I think that it's.
right, that's,
It's either from the get-go or
that's,
remains just with us.
yeah, that's a better way of saying it.
So what are y'all saying? Let it stand the way it is, or add a resolution?
Is it improper to ask I don't know how this happens within the village, like to ask the like put this on for another month, ask the board if they would, like, have they thought about this? Or they're like, no, this is all yours, and we're just wasting time and effort
Well,
to push it forward,
They're not involved in this at this point.
right? But do they know if they even have an opportunity to be involved in it?
Well, I think as Courtney said, if you guys decide to refer it to the village board, they could decide to refer it back, right? So
Right.
if they don't want to hear it, they could just refer it back.
I would say that once we finalize and approve this, it could go to the village board for a final review, and they can provide comment. They can't overturn the decision, but they can provide comment to the resolution.
I don't know if that's a process or not. Did you hear that, Drew?
That's the correct, it would be, that's the final process now. Right? I would report, here's the ABR's ruling on the matter, and I would report it to them, and that's the end of it.
Well,
That's the current process.
But what Scott is saying is they would have their review of it to make comments, so now they become the advisory body to us in a way.
But they would
When
not
it's
be
all
able to
done by
overturn
then.
the decision to approve the exemption.
again,
They
that would
couldn't-
have to
They
be
couldn't
a-
deny the exemption.
Again, that would have to be a condition, I mean,
Yeah, I don't think that's any different than you guys voting on this tonight and not having a condition for the village board weighing in. What you're suggesting, saying is, here it is, you're saying you can't, are you suggesting they can add additional conditions but not affect the exemption outcome?
Yeah.
I mean, that could be a condition.
it could be
It's
a
a little
condition.
unusual, but you can do
It's-
it.
yeah.
What about the one that Drew mentioned where they see it, they know how we voted, and they see our recommendation, and they have X amount to their next meeting, or the X amount of time to review it, or vote on it, or whatever, and if that expires, or they don't do it, then it stands.
I did think of another example where that happens in the
Okay,
zoning
where
code
is
with
it?
extensions of variations. If an extension, or if there's been zoning relief granted and administratively, after a certain time frame, I can approve it, and I report that to the village board, they can change that outcome if they didn't like it. So it's very similar, saying like, this is good, it's effective this date, and only the village board can take action and do anything differently before that date, but otherwise, this will be effective at a date certain.
Does anybody see a problem with that? Or like is that at least it's sort of a back check, when they can just pass on it if they don't want, if they think it's fine. I don't know. Opinions?
Yeah, it just seems odd that they kind of back check a lot of our work, and this is the one that we're not having them back check. That, I don't know, it just feels like this is the most important thing that we do. Signs is signs.
My issue with having them back check our work is that they are not familiar with our work. That this is fairly technical in a way,
Right.
Yeah,
it's complicated, and there's more than just
yeah.
the strict interpretation of the code involved.
Then if you're saying we're the most authoritative power,
We are.
then maybe that's
Maybe that's-
states
Yeah,
that,
that's a good point.
then why go up if they're not more authoritative on this
I mean-
issue?
Yeah,
that, I mean, the only thing bothersome to me is when Chief Graff, wasn't on board with us.
Of course not.
Right. And I don't know if you'd ever be on board with anything that's not sprinkled, so maybe that's a non-issue issue. But we've always felt that this is sudden, I still feel like, this first one is the test for everybody coming up. And we just need to make sure that we're doing the right. I know you're saying the same thing, but.
Yeah. And I think anybody else that comes up is gonna have a different set of circumstances.
Right.
This one, to me, is pretty unique for all the things we talked about last meeting.
Yeah. So if the village board's not gonna vote on what it means to the village for this to happen, right? I don't know what their interest in this is. Right? If they're not protecting the interest of the village by approving this, if that's already protected by what we're doing, I'm not sure what the village board's role is then.
I think to your point, you just said you wanted and drew a second pair of eyes on it for.
Yeah, but Bob mentioned that
subject to
the second pair of eyes aren't as
But
informed as we
Yeah,
are.
the second pair of eyes is not a knowledgeable pair of eyes. That's why I said in the beginning, when I first brought this up to Drew, I should have to go to the village board and explain why I'm here and why we decided what we decided and go through the whole routine. And suggest that they watch the video of that whole meeting.
So,
That's about 8 hours of testimony. That's a lot of testimony.
Excuse me.
And you are all
The last meeting I'm talking about, and I didn't expect for you guys, it didn't occur to me that you guys would want to be there, and of course you would.
yeah, we do the whole dog and pony show again, because someone coming cold in on this just does not have the background or understanding.
Exactly.
So it would be the whole dog and pony show again. This ordinance has been, or the exemption ordinance has been on the books for almost a year. So, everybody's thought about this, and now to throw this in at the 11th hour just seems to put us in limbo and uncertainty and it.
and we would disagree that you can make a condition to send this to the board. The ordinance says, after considering the information and materials provided, the architectural board of review may approve the exemption, may approve the partial exemption, may approve the exemption with conditions, or approve an exemption for a limited period of time or deny the exemption. It doesn't say you can just add any condition. It says, approve the exemption with conditions. Approve
It
it.
would be a
With the
condition.
condition that it would
Approve
go
the exemption.
to the board.
For what?
It's a,
You're-
the
you have
board
to
can
approve
impose
the
any condition
exemption.
it wants for approval. If it wants to approve,
That's not a reasonable condition based on the
that's,
language of the.
that's up to the board to decide what's a reasonable
It's
condition.
not. It's right here in this, it's right here in the ordinance. But, our attorneys argue, so I get that. Go ahead, Drew.
All I was gonna say, Bob, if you will vote on the resolution tonight, as you guys have been currently considering, without this additional condition, you're certainly welcome to come and report. That happens too. If you wanna say, hey, just so you know, it was a tough one, we went through it, this was our result, you have any questions? You can do that. You can do that.
That's necessarily something I want to do.
It's always available.
And the consensus seems to, if there's consensus, you can direct Drew to go back and have staff put together a new ordinance for the next applicant, and you can send it to the board. But I just read the language of the law that's been passed by the board, and it doesn't say to send it back to the board. It doesn't say that. It says you decide. You approve it with conditions, not you approve it and send it to the board. That doesn't make sense. So we ask that you approve it tonight. Thank you.
Okay, we can approve it with conditions if we feel like it, and so we're going to take a vote, or any more discussion on whether we should
had-
do that? Yeah, or
I had just one thing, and I'm going back now, and I
Don't do
apologize.
that.
I apologize. Did anybody talk to the chief about these?
He was here.
I know, but, has he seen this list of conditions and had an opportunity to
I don't
comment?
think unless you talked to him, Drew, I don't think we talked to him after the last meeting, but he was here when we discussed
Right,
putting the
I
conditions
understand.
in.
And I asked him
Yeah.
specifically, do you want to add anything
Yeah,
to these
no, we-
conditions?
Very good.
And he said
Very
no.
I think we cleared
So I
that.
think it was during the meeting that we had that conversation. Yeah.
are we ready to decide what to do here? Should we call for a vote on,
I think we need to decide if the board wants to include a condition
yeah,
that it would be subject to board concurrence.
okay. Did you hear that? Do we want to include a condition that this would be subject to the, submitting this to the village board? Basically, is that what you said?
So this would be a vote not to approve the resolution, but just to approve whether or not to add that additional condition.
Well, it'd be both, I think.
2 items.
We'll have two separate votes. This would just be, first of all, I think we're deciding if we'd like a condition, language for a condition for board concurrence. And if that's the case, we'll do a motion to amend the resolution with language drafted that I can read into the record, as well as the exemptions or the revisions to, provided by the applicant. And then if that's agreed, we would do, second and a roll call on that to amend that and include that language with the revisions. And then we would do a second vote to approve the amended resolution.
Can I ask this, not to say gas on the fire already being burned? If we, because we have this in front of us, I mean, can we not vote? I mean, could we just not vote to approve this? I'm just asking where we are right now. Is there any world that we just say, we don't approve this? Or is that not in our world?
So that it is, in the sense that nobody's made a motion to approve the resolution that's in.
So everything's up in the air.
Yes, there's not a motion on the floor.
So if we wanted to go to the board, that's one way to do it. It's not a fair way, but I'm just saying, there's nothing right now that says we're doing anything
There's no motion,
specifically.
and there's no second, nothing's being considered. You're just talking about the next steps, which you could do.
Yeah,
You could say, you can make a motion that's different than what's
Yeah.
being lined out. Yeah.
so if we made a motion to deny this, we could do that,
To deny what?
this whole thing,
The exemption.
the exemption. I'm just saying, where are we right now in the process? I'm not saying I want to, I'm just asking.
Yeah, I think right now, as was being outlined by village attorney Courtney, sorry, Willits.
Okay.
Thank you. Willits came to me momentarily. Yeah, so I mean, I think this is like, you're at the point now where you've had a conversation, and now you've been presented some slightly nuanced language, the lowercase b and c,
Right,
and I think just my gathering of consensus, like nobody had any heartburn with that.
Right, yep.
And the other massages, was there actual massages to the language in the other?
Yes.
Yeah, that there was no
So-
heartburn with those?
No, right.
And so now it's just really the idea is, I think that there's consensus around that. It's just now, do you add this other condition or not? And if somebody did or didn't want to do that, they can make a motion to say, I want to approve this as we've discussed without that additional or with it. And then that gets looking for a second procedurally. And I think that's where you're at.
So what you just said is a little different than what Courtney said.
It was, well, I think Courtney was talking about having a conversation, almost having a straw poll on this other condition first, but you don't have to do that.
Well,
You
we
can-
kind of have been doing that.
Yeah, yeah.
And I'm not sure that we've reached any kind of a consensus on that yet. But the basic thing is village board or no.
Well, that was Courtney's first suggestion.
That was her first suggestion. Do
And I
we
think
say yes
should
or
have a
no
motion and a vote
on?
on that, and then follow it up with what Courtney suggested for the second one.
Okay, then let's do that.
So
We need,
we currently don't have a motion. We do have language drafted for the condition, which would need to be read into the record if that's, so we can amend the resolution and present it to the board, if that's what the board would want. So I can read that language, and then I guess if everyone is okay or would want to go forward with a board concurrence, this would be the language that would be included as a condition for the resolution. And then we would need to, vote on
so we vote
that amended
yes or no, and
resolution.
if we so say no, then we vote on this one with the adjustments that we made.
Yes.
And when you say concurrence, they are concurring with granting the exemption, or they are concurring with the way the resolution is written? Because those are two pretty different things.
The,
Can they overturn our decision to grant the exemption?
If we put it on to them, they could.
Yeah,
Subject
we-
to
if-
their,
that seems redundant.
Otherwise, we're just wasting time.
Well, there's nuance in this document, and they could maybe be another set of eyes that has a suggestion, to adjust the nuance, but not overturn the whole thing. I think it seems very redundant to have to start over again with another board, because it's very involved, there's a lot of facts and a lot of stuff to sort out. And we're a smart group of people.
Yes. Okay, so we need a motion.
Courtney, could you read what you've got?
Sure.
So one of us will say so moved.
Yeah, okay. The board acknowledges that the village is a home rule unit of local government and that the village board of trustees is responsible for the overall general health and safety of the village and its residents, and that pursuant to its home rule authority, the board of trustees may, notwithstanding other provisions of the municipal code and this resolution, determine that approval of the exemption for a fire sprinkler system at the subject property is not in the best interest of the village and its residents, and may desire to deny the exemption for a fire sprinkler. Therefore, the fire sprinkler exemption for the subject property as set forth in this resolution is made explicitly subject to concurrence by the village board of trustees.
When was this language prepared? We never received this.
I didn't get that. That gives them the authority to reject it, but not to accept it.
It's up to, again, the language is stated that they may desire to deny, but the fire sprinkler exemption set forth in this resolution is subject to their concurrence.
Okay.
But it's so, the language is so slanted against approval. It's not in the best interest of the municipality. I mean, come on.
That's what the board has to determine, that it's not in the best interest.
Okay,
That's a condition.
so,
That's the language presented.
so we need a motion to either accept that as a addition to this, or,
Yes, we'd either
Denied.
need a motion to amend the resolution to include that condition for board concurrence. I guess we should probably just do that separately, to include the condition for board concurrence, as well as these. I'm sure if everyone is
the little changes.
okay with these. And that's where we are right now. We would need a motion for that.
So who wants to make that motion? If anybody,
I'll make the motion. I'm going to vote against it, but I'll make it.
okay,
So moved.
I'll second.
okay. Well, this is a voice vote, and everybody knows what we're voting for, basically, send it to the board or not.
Oh, okay, so roll call vote.
So roll call.
Member Wicks?
Start down there.
You can start down here if you want.
They made the motions, though. Do you want me to just come back to you?
Yes.
Okay.
Thank you.
Member Stradiff?
Let me think.
Nay.
Member Kerouac?
No.
Member Dahlman?
No.
Member Cottrell?
Yes.
Okay, and Member Wicks?
Well, I guess it doesn't really matter. I think it should go, I do think it should be yes. I
Okay.
say yes.
And Chair Hunter?
I brought it up, but I'm gonna say no.
So the noes have it, right? 4-2?
Right.
Yep. Okay, so that condition does not pass.
You brought it up. I made the motion. We both voted no.
Yeah, I know. I brought it up,
It's
you
a,
know,
we
2
need
weeks
to,
ago, or
I
whatever it
believe
was, and,
we needed to hash it out. I think it's a good thing to hash out.
yeah.
So
And
that being said, since that included, we should do another motion to amend the resolution to include the revisions proposed by the applicant for section 5, paragraph 2, the building code will not be capitalized in the last sentence. Number 3 will read, the owner must connect the 966 unit to the existing centrally monitored fire alarm system at the subject property. Number 4, are we keeping?
No, they agreed to drop
Village
that
staff,
one.
okay.
right.
And then for number 5, the owner must verify that the subject property has an addressable alarm panel that indicates to the fire department the location of the smoke detectors that sent the alarm signal.
Then you say that's there.
So we need a motion to amend the resolution to include those revisions.
So moved.
Second?
Second.
Okay, roll call.
Okay. Member Cottrell,
Aye.
Member Dahlman,
Aye.
Member Kerouac,
Aye.
Member Stradiff,
Aye.
Member Wicks,
Aye.
and Chair Hunter.
Aye.
Okay, motion passes.
Okay, now we
Make it easy
need,
for us to make motions.
well, now, so that's to amend the resolution, so now we need a motion to approve the resolution as amended.
Okay, who wants to do that?
I move to approve the resolution as amended.
Second.
Okay,
Roll call.
okay. Member Wicks,
Okay, so,
These are the slight amendments, changing the capital letters.
oh, we're
Yeah.
just, we're.
Yeah.
Approving the
amending
resolution.
what- Okay,
What's
yeah,
in
okay,
Yeah.
yes, then.
okay. Member Stradiff,
Aye.
Member Kerouac.
Aye.
Member Dahlman,
Aye.
and Member Cottrell,
Aye.
and Chair Hunter.
Aye.
Okay, the resolution is approved.
As amended with
Right,
the applicant's revisions, yes.
yep.
I'm sorry, I muttered the water.
Let's muddy it now so we can not have to deal with it after someone else.
Sure, you're welcome.
Thanks, guys.
I was exhausted.
So what else do we have? Anything, Mike?
No, I just had in the staff report about Tesla withdrawing their application
You know,
there.
I didn't notice that article that was on the backside of that page.
Oh, yeah,
So they may never come back.
who knows, yeah,
Maybe
right,
they fired everybody.
right, yeah,
Did you see that?
Yeah, it's crazy.
yep.
So we went and, Member Wicks and I went and visited the charger stations up in Waukegan. They're big. It's not so I'm glad we don't have to deal with it.
Me too. I don't think I
Yeah.
could do that again.
Yeah,
Well, it may come back, but maybe, maybe not.
yeah.
Okay. so
Let's get
that's
back to
it.
signs.
So we need a motion to observe.
This is like a courthouse.
The outdoor planting plan and the furniture is included in the budget. We're ordering the furniture this week. It's a May 1 budget, so it's all new. And so we're putting out to bid the other planting, so trying to get it done this summer.
That's so great.
That's,
Excellent.
okay.
Thanks for good news.
Thank you.
Yeah, right. We like kosher chairs
All
and
right.
flowers.
Need a motion.
We need, somebody needs a motion to adjourn.
I move to adjourn.
Second.
Second?
Second.
Adjourn? Second?
Second.
Oh,
Okay.
Voice.
All in favor?
Aye.
Okay, meeting is adjourned.
Do I need to show you something?
All right.